Hello everyone. Today let us discuss this very important Supreme Court judgment which has declared the Electoral Bond Scheme as unconstitutional. So let us go through the legal nuances and also some of the observations of Supreme Court. Now, when we talk about electoral bond or this scheme, it is for political funding. So it was challenged under Article 32 with respect to constitutional validity on one end with respect to transparency or freedom of speech and expression under Article 19(1)(a), and on the other end with respect to privacy under Article 21 of the Indian Constitution. And that's why if you read the newspapers, you will often find this word anonymous electoral bonds because the name of the donor is not disclosed. Now, the basic premise is that can curbing black money, which is also one of the stated objective or stated goal by the government for introducing this electoral bond, can this be one of the ground of reasonable restriction under Article 19(2)? Because if this can be said so, then Article 19(1)(a) with respect to transparency could be reasonably restricted under 19 clause 2. So very simply, the question was that can curbing black money said to be a reasonable restriction or a ground for reasonable restriction under Article 19 clause 2 vis-a-vis freedom of speech and expression under RTI regarding transparency. And based on this and other premises with respect to electoral financing, this judgment has been delivered. Now, when we talk about electoral bond scheme, so on one end, this issue is with respect to transparency vis-a-vis privacy, and on the other end, there is another issue of electoral finance, right? Now, when we talk about electoral finance, then this particular scheme, that is the electoral bond scheme, this was introduced through the Finance Act of 2017, and it proposed amendment in 4 legislation: the RBI Act, the Representation of People Act 1951, Income Tax Act, and the Companies Act to facilitate the electoral bond scheme. So let us go through these legal nuances to understand the judgment and also simplify the Supreme Court judgment which has been given about electoral bond scheme. So if we look into this basic aspect of transparency vis-a-vis privacy, that is, is transparency allowed vis-a-vis privacy, then on that note, the court went into extreme length to understand this whole aspect from not only from the perspective of privacy laws, but also from the perspective of the overall electoral financing and the politics behind it. So in a nutshell, we can say that about this particular judgment or its major highlights, it says that information on funding of political parties is essential for voting, and this information is curbed through the electoral bond process because the name of the donor is anonymous. It further says economic inequality contributes to political inequality due to deep association between money and politics. So the court also went into extreme detail about money and politics and what role does money play during the electoral practices, or the role of money power in order to with respect to the electoral practices, and what kind of disturbances it can introduce in a democratic polity. It then says right to informational privacy includes political affiliation as it can be used by state to suppress dissent. Now the point highlighted here is that with respect to citizens, they do not know that who the donors are, but the government knows that which individual or companies have donated and to which political party. So this information is very much one-sided, and state can, by using these information, put certain curbs or put certain dissents, let's say, on those companies or on those political parties which has given money to some other political parties. So on this note, it says that lack of privacy of political affiliation would disproportionately affect those whose views do not match. So there is element of disproportionality. Another thing highlighted here is that money raises the legitimate possibility of quid pro quo Obviously, if a particular company is providing some money to a political party and that political party comes into power, then that company would expect something in return or something back in return, let's say a favorable policy. So this is also something the court have taken notice of. Says that therefore the Electoral Bond Scheme violates Right to Information Act, Right to Information under Article 19(1)(a), which guarantees freedom of speech and expression. Now the reason given by the Supreme Court here was that under Article 19(1)(a), freedom of speech and expression could be curbed on one of the reasonable grounds provided under Article 19 Clause 2. But curbing black money cannot be said to be one of that reasonable restriction or grounds under which reasonable restrictions could be imposed. Now this is one part of the judgment. Coming to the other part of the judgment with respect to the amendments which were introduced by the Finance Act of 2017. And the amendments introduced were under Section 31 of the RBI Act, Section 29C of the Representation of People Act, 13A of Income Tax Act, and Section 182 of the Companies Act. And all these amendments ensured a free or a smooth process for political funding through electoral bonds along with anonymity. So all these ensured anonymity. And this is what was under consideration in this writ petition filed by Association of Democratic Reforms versus Union of India. So before going into the nitty-gritties of the legal nuances of the scheme, let's first of all understand about the Electoral Bond Scheme itself. Now this scheme was issued in January 2018 by Ministry of Finance in the Department of Economic Affairs, which notified the Electoral Bond Scheme in exercise of power under Section 31(3) of the RBI Act. Now this is important for us to understand. It says electoral bond is a bond issued in the nature of promissory note. So it is in the nature of a promissory note, which is a bearer banking instrument and does not carry the name of the buyer. Here comes the anonymity clause of the Electoral Bond Scheme. Now talking about Section 31 Clause 3 of the RBI Act, based on this amendment, even RBI raised certain concerns, which we will look into later. So first of all, let's go through Section 31 of RBI Act, which says that issue of demand bills and notes. And it says that no person in India other than the bank, that is the RBI, or as expressly authorized by this act, the central government shall draw, accept, make or issue any bill or exchange hundi, promissory note or engagement for the payment of money payable to bearer on demand. And clause 3 says that notwithstanding anything contained in this section, the central government may authorize any scheduled bank to issue electoral bond. And the scheduled bank was State Bank of India. Now it says that for the purpose of this subsection, electoral bond means a bond issued by any scheduled bank under the scheme as may be notified by the central government. So the central government issued the Electoral Bond Scheme of 2018. It further says that the scheme has notified the State Bank of India as the bank authorized to issue and encash bonds by individuals and also persons, that is also by companies. Now the question is, which political party can use these electoral bonds? Not all political parties. So here again the question of violation of Article 14 comes into picture. It says that an electoral bond can only be encashed by an eligible political party under Section 29A of RPA. Now what is Section 29A? What is the criteria provided here? It says a political party to be eligible to receive an electoral bond has to be registered under Section 29A of the Act and should have secured not less than 1% of the votes polled in the last general election, either in the parliament or in the state assembly. So this is the criteria for the political party to receive these electoral bonds. Now another important point is with respect to the amendments which has been proposed in other legislations as well. Now, the purpose of these amendments was to ensure anonymity of these electoral bonds. So it says that under RPA, an amendment introduced in section 29C on declaration of donation received by the political parties. So any donation received by political parties in excess of 20,000 through electoral bonds need not be audited. Section 13A of the Income Tax Act added that political party was not required to maintain a record of the contributions if the contribution was received by electoral bonds. So basically, they need not require any accounts. And Companies Act made an amendment under section 182. Now earlier, it provided for certain barriers or a cap that only certain companies having certain profit could participate or provide political funding But this cap or barrier was removed through this amendment under the Finance Act. So it says, amendment to section 182 removed the cap that barred companies from donating more than 7.5% of their average net profit to a political party. Now this bar has been removed or was removed, and now any political party could provide political funding through electoral bonds. Also, subsidiaries of foreign company under FEMA could also provide for political funding through the electoral bonds. So the issue is that any company, even though that company is a loss-making company, could provide funding through electoral bonds. So all these were the issues with respect to electoral bonds. Now just let's go through section 29C of the Representation of People Act of 1951. It says declaration of donation received by political party. So it says the treasurer of a political party or any person authorized by the political party in this behalf shall in each financial year, so they have to provide accounts for each financial year, prepare a report in respect of the following: that the contribution in excess of 20,000 rupees by such political party from any person in that financial year, and the contribution in excess of 20,000 rupees received by such political party from companies. However, a proviso clause was added here. Now, what does this proviso clause say? It says that provided that nothing contained in this subsection shall apply to contributions received by way of an electoral bond. So basically, no restrictions for electoral bonds. Now, another issue which was also highlighted during the arguments in the Supreme Court was the distinction between electoral expense by individual, right, or individual candidate, and expense by political party. So the argument was that under the Representation of People Act and Conduct of Election Rules, there is a cap or there is a limit on expense. For Lok Sabha constituencies, it varies from 75 to 95 lakhs. And for state assemblies, it varies from 28 to 40 lakhs. This is what the expense is. And this is also according to the Conduct of Election Rules. So the argument made was the electoral funding the political funding provided through these electoral bonds were for expenses of the political party and not for the electoral expense, which anyways is regulated. So the question was how to regulate this expense of political party. So if you go through section 77 of Representation of People Act, it says that, or it mandates that every candidate or his election agent to maintain an account of all expense incurred for election authorized by him or by his election agent between the date on which he has been nominated and the date of declaration of result. So he has to provide the details of his expense. But this restriction is for a candidate, not for a political party. and these are the limits which was enhanced during the COVID times. So this is one of the issue which was also raised during the arguments. Now, this is what the summary of the court is. This is what the court understood, that based on amendment proposed through the Finance Act of 2017 under Representation of People Act, under Income Tax Act and the Companies Act. So the court says that the effect of the amendments introduced by the Finance Act to the above legislation is that a new scheme for financial contribution to political parties is introduced in the form of electoral bonds. Fine. Political parties need not disclose the contributions received through electoral bonds. Here come the issue of anonymity, which the state argued that this anonymity was with respect to protecting the privacy of such persons under Article 21, because Article 21 provide for the word person, and hence the word person includes both individual and companies, right? It then says that companies are not required to disclose the details of contributions made in any form. So basically there is no cap on political contribution. Any corporate can provide any, there is no limit, any number of, any amount of money as political contribution through the electoral bonds, and all these information are anonymous. Now coming to an important aspect of concerns raised by RBI and also the Election Commission. Now RBI says that amendment under section 31(3) of the RBI Act would enable multiple non-sovereign entities to issue bearer bonds. So this was one of the concerns of RBI. But the state argued that this is not a valid concern because this electoral bond would only be valid for a period of 15 days. So there is no need to worry. The proposal militated against RBI's sole authority for issuing bearer instruments, which has the potential of becoming currency. But the government said that its time or its limit is its duration is very limited. Hence, one need not worry. It then says electoral bonds can undermine the faith in banknotes issued by the central government if bonds are issued in sizable quantities. Further, RBI stated that though the identity of the person or entity purchasing the bearer bond will be known because of the KYC requirements, and the identities of the intervening person or entities will not be known. This would impact also the principles of Prevention of Money Laundering Act of 2002. It then says the intention of introducing electoral bonds can be accomplished by other methods. Now here comes the concept of least restrictive method, also provided by or also stated by the Supreme Court. Now according to the least restrictive method, the Supreme Court said that, let's say, because this was an issue between two fundamental rights, let's say Article 19(1)(a) and privacy under Article 21. And the objective of the state was twofold: to curb black money and to ensure privacy with respect to political donations or voluntary political donations or political contributions, right? So the question was that, is restricting right to information under 19(1)(a), the question was, is restricting right to information under 19(1)(a) by issuing these electoral bonds the only way? Are there any other ways available? Or are there other less restrictive ways which would not impact so much on the aspect of privacy? Right? So this was one element of least restrictive method, which was also stated by Supreme Court. So coming to the concerns of RBI, RBI stated that intention of introducing electoral bonds can be accomplished by other methods, which includes by check, demand draft, and electronic and digital payments. And there is no special need to introduce a new bearer bond in the form of electoral bonds. Now, this point was also raised by Justice D.Y. Chandrachud on the principle of double proportionality. Now, double proportionality refers to balancing two fundamental rights. As we have stated that here the two fundamental rights are 19(1)(a) with respect to transparency through RTI or informational disclosure, and privacy under Article 21. So, how do two different fundamental rights compete against one another? So, this was the principle of double proportionality. And on applying the principle of double proportionality, Justice D.Y. Chandrachud found that this was not equal, and the step taken to ensure privacy or anonymity for electoral bonds was disproportionate, right? So this was one of the reason provided by Justice Chandrachud based on this concept of double proportionality, whereas Justice Khanna said or mentioned about proportionality test. Now, under proportionality test, any state action is judged on grounds of violation of any of the fundamental rights. And here Justice Khanna highlighted that curbing black money as one of the objectives of the government could not be one of the legitimate, basically it violated fundamental right, and it was disproportionate basically. So this was the whole outcome of this judgment. Now, coming to another important aspect of concerns raised by the Election Commission. Now, Election Commission raised concern not only with respect to Companies Act but also with respect to the Income Tax Act. Now, with respect to Representation of People Act. So the Election Commission states that amendment to the Income Tax Act, RPA, and Companies Act introduced by the Finance Act 2017 will have a serious impact on transparency of political finance and funding of political parties. So he's saying that it will not lead to transparency but rather will lead or will become more opaque. Any donation received by a political party through electoral bond was taken out of the ambit of reporting under the contribution report as prescribed under section 29C of RPA 1951. So under contribution report, you have to provide the details. But again, that element was also taken out through amendment. So it says that this is a retrograde step and will affect transparency of political donations. So this was one of the concerns raised by Election Commission. Another concern is with respect to Companies Act, with respect to or regarding section 182, which provided a certain cap. So it says that ECI expressed its apprehension to the deletion of the first proviso to section 182, which put the cap on corporate donations, or through which the cap on corporate donations was removed. It then says ECI recommended that the earlier provision prescribing a cap on corporate funding be reintroduced. Why? Because unlimited corporate funding, the aspect which was also raised by the Supreme Court in its judgment, unlimited corporate funding would increase the use of black money for political funding through shell companies, right? And then capped corporate funding ensured that only profitable companies with a proven track record could donate to political parties. So these were the grounds, or these were the reasons as to why those cap of only those companies should provide donation through electoral bonds, having a net profit of 7.5% in the last 3 years. So overall, the question was that first, whether unlimited corporate funding to political parties as envisaged by the amendment to section 182 of the Companies Act infringes the principle of free and fair elections and violates Article 14 of the Constitution. Okay. And then it says that whether the non-disclosure of information on voluntary contributions to political parties under electoral bond scheme and the amendments made in these three different legislations are violative of right to information of citizens under Article 19(1)(a) of the Constitution of India. The answer was, of course, yes. And all these amendments are or has also been declared as unconstitutional along with the electoral bond scheme itself. Now coming to the judgment. The judgment has two parts. One with respect to the aspect of right to information vis-a-vis privacy and electoral financing on one hand, and on the other hand, directing SBI and ECI, that is Election Commission, to publish all the documents from the date of their interim report, that is from the 12th April 2019. So going through the first part of the judgment, it says electoral bond scheme and all these amendments are violative of Article 19(a), 19(1)(a) and unconstitutional. And here the court highlights that if you have to restrict Article 19(1)(a), then the grounds for reasonable restrictions must be found under Article 19(2). And curbing black money is not one of the grounds to restrict freedom of speech and expression under 19(1)(a). It then says that deletion of the proviso to Section 182(1) of the Companies Act permitting unlimited corporate funding also to political parties is arbitrary and violative of Article 14. So the doctrine of arbitrariness was applied to find out or to check whether it violated Article 14 or not. It then says the court has directed the disclosure of information on contributions received by political parties under the electoral bond scheme, that the issuing bank shall herewith stop the issuance of electoral bonds. So these are some of the important highlights with respect to this judgment. Now in these judgments, some of these principles was also highlighted, and we have also discussed some of these principles. So when we talk about the proportionality principle, here a state action is judged with respect to violation of any of the fundamental rights. State action is judged with respect to violation of any of the fundamental rights. This was checked by Justice Khanna. Justice Chandrachud applied the double proportionality test, whereby two fundamental rights, fundamental right 1 and fundamental right 2, that is here Article 19(1)(a) and let's say Article 21, were judged, and it was to be found that 19(1)(a) or restrictions imposed with respect to privacy on the aspect of anonymity of electoral bonds was disproportionate. This one, that is, what was the impact on the fundamental rights? So the impact of issuance of electoral bond was that it was disproportionate because it restricted freedom of speech and expression for the citizens. And for the citizens, knowledge about electoral financing is also very important. Least restrictive method, we have already discussed that was electoral bond the only way to curb black money and to ensure privacy of citizens? Was there any other alternative method? Because according to RBI, there was one, and even Justice Chandrachud, I think, suggested a concept of electoral trust. So the question was, why other less restrictive method were not tested? Why restrictive? Because electoral bond scheme restricted fundamental right under 19(1)(a), and that restriction was unproportional or disproportionate. Now this concept of proportionality was introduced in the case Puttaswamy judgment, where it held that privacy as a part of Article 21 is not absolute. privacy is not absolute, and state can take reasonable step to restrict privacy if it satisfies three aspects or three grounds. The first is legality. There is a law. Need. And the third is the principle of proportionality. So the principle of proportionality says that whatever step has been taken to achieve the objective is that proportional. For example, let's say someone has committed a theft, and the court gives them capital punishment. So that is unproportional or disproportional. So what is the step taken to achieve the objective? And is there a rational nexus? And is the step proportional? Now, this aspect was also highlighted by Justice Chandrachud in the minority judgment of Akther. So this is with respect to the proportionality principle. So then it says that SBI, okay, coming to the second part of the judgment, where SBI and ECI have to provide for disclosures. So it says SBI shall submit details so that anonymity is removed of the electoral bonds purchased since the interim order of the court dated 12th April 2019 till date to ECI, and the details shall include all of these, that is, date of the purchase of each of those electoral bonds, name of the purchaser of the bond, and the denomination of the electoral bond purchased. So date of purchase, name of purchaser, and denomination of the electoral bond. So this will ensure transparency under RTI, which can also be said to be a part of freedom of speech and expression under Article 19(1)(a). It then says that SBI shall submit the details of political parties which have received contributions through Electoral Bond Scheme since the interim order of the court dated 12th April 2019, and SBI must disclose details of each electoral bond encashed by political parties, which shall include the date of encashment and denomination of the bond. Further, SBI shall submit the above information to ECI within 3 weeks from the date of this judgment, that is by 6th March 2024, and the ECI shall publish the information on its official website by 13th March 2024. So all these are part of transparency process, that whoever has purchased that electoral bond and whichever party has purchased, all has to be published. It then says electoral bonds which are within the validity period of 15 days, but that which have not been encashed by political party yet shall be returned by political party to the purchaser depending on who is in possession of the bond to the issuing bank, and the issuing bank, SBI, upon return of the valid bond shall refund the amount to the purchaser's account. So this is the second part of the judgment with respect to ensuring transparency about purchase of electoral bonds from 12th April 2019, because that day interim order was issued by the Supreme Court of India. So these are some of the important highlights with respect to the Electoral Bond Scheme, which has been declared unconstitutional, and the amendments proposed through Finance Act 2017 in the Representation of People Act, in the Companies Act, and the Income Tax Act. All the three amendments have also been declared unconstitutional. And Justice Chandrachud has stated that privacy cannot be one of the grounds of to curb fundamental right, to curb freedom of speech and expression. Curbing black money is not one of the reasonable restrictions provided under Article 19 Clause 2. Thank you very much.